Coming up today.
Sir, has the RCMP contacted you regarding Justin Trudeau's role in the SNC LAVALIN scandal?
2 days before your infamous December 19, 2018 telephone call with Jodi Wilson-Raybould, in which you specifically raised the issue of the 9,000 jobs at SNC moving its headquarters.
Hang on, Mr. Cooper.
Over that 4-month period, there were approximately 10 phone calls, 10 meetings about SNC LAVALIN, culminating in a phone call I had with the clerk of the Privy Council on December 19th. Now, you didn't know that you were being audio taped, did you?
No.
No.
So help me just get a sense for, when the telephone conversation happens between you and the former Attorney General, and you say the Prime Minister is in a kind of a mood. And there's an assertion that he wanted her to shelf the prosecution, and it says in quotes that he's in a pretty firm frame of mind about this. So I'm a bit worried. What would you be worried about? This is your language from the recorded conversation. Yeah, you're asking me to dredge up memories from 5 years ago, and I gave my testimony.
Point of order.
Hang on a second, Mr. Wernick. Mr. Barrett, on your point of order, please.
Chair, you intervened in the previous round with very clear expectations about what's supposed to happen. Mr. Green's question was very straightforward to the witness.
Jodi Wilson-Raybould, the jobs were on the line, and there was a risk of SNC moving its headquarters when you had to have known that that simply wasn't true.
That was my understanding at the time, and that the law that Parliament created in terms of deferred prosecution agreements.
How is it possible that could have been your understanding at the time in the face of everything that I laid out?
Will you let him finish, please?
Will you let me finish?
You're badgering. Your answer is simply
point of order. Mr. Brock.
Chair, I'd like at this time to move a motion.
Mr. Barrett insists on using words like cover up and corrupt, and he knows that I'm going to get my inbox full. Already social media is talking about me being a pearl clutcher.
This guy's garage. Like and subscribe.
I'd now like to welcome our witness for today, Mr. Michael Wernick, former clerk of the Privy Council, and we are going to start with Mr. Barrett for 6 minutes. Mr. Barrett, go ahead.
Sir, has the RCMP contacted you regarding Justin Trudeau's role in the SNC LAVALIN scandal? His response was not audible.
Yeah. Mr. Wernick, sorry, you're going to have to hit unmute. There you go.
Oh, sorry. The usual Zoom mute, unmute. Sorry, I did hear the question, sir. No, they have not.
But you were interviewed for the Ethics Commissioner's report, the Trudeau 2 report on the SNC LAVALIN scandal. Is that correct?
Yes, I retired in April of 2019, Easter weekend. I was interviewed one time by the Commissioner in the preparation of the report. I was interviewed by the RCMP that summer about the lobbying activities of principals of SNC LAVALIN.
And did you have any further contact with the RCMP following, with respect to SNC LAVALIN, following that interview in 2019?
Never prior and never after.
Did the RCMP ask you about, did they ask you any questions dealing with Justin Trudeau?
That was 5 years ago. I do not remember the flow of the interview. We basically went over the material, which you will see in the Commissioner's report.
You don't remember if the Prime Minister's name was said by the RCMP? I can tell you, I've as part of complaints that I filed with the RCMP, have been interviewed by them, and it was years ago. I remember very distinctly how that interview went, and I certainly would remember if the Prime Minister's name was mentioned. It was, I can tell you, in my case. Was the Prime Minister's name mentioned? Was a question asked of you about Prime Minister Justin Trudeau when you were questioned by the RCMP?
The interview took the form of going through the chronology of events, who met with whom, who spoke with whom, communicated with whom, and so on. And so, yes, the role of the Prime Minister came up because I was in contact with the Prime Minister during that period I was clerk.
The question of obstruction of justice, which is a criminal offense, was raised with respect to the Prime Minister's involvement in the SNC LAVALIN scandal. This is, of course, events in which you were involved. Most Canadians would have expected that you would have been interviewed on that subject. Do you think you should have been interviewed in the RCMP's pursuits with respect to obstruction of justice concerns or allegations about Prime Minister Justin Trudeau?
I have no view on that, Mr. Cooper. It's up to the police who they decide to interview.
Thank you very much. My esteemed colleague, Mr. Cooper, will have questions for you later. I'm Michael Barrett, and I did have the opportunity to ask you questions when you appeared at the Justice Committee about the SNC LAVALIN scandal, and I'm glad that we have you here today as well. Do you have any view on who the RCMP should have interviewed? We have a list of who the who the Ethics Commissioner interviewed. We know who the RCMP interviewed, but those lists aren't the same. Justin Trudeau, Katie Telford, Jerry Butts, do you think they should have been interviewed to exonerate the Prime Minister?
I have no view on who the police should choose to interview. Not every issue of ethics or behavior rises to the level of a preliminary investigation or fact-finding or examination. Not all of those move on to a full investigation in the terms that journalists and politicians use them. These are decisions to be made by the police and by the prosecutorial service.
We know that the Prime Minister broke the law. That's a matter of public record, him having broken the Conflict of Interest Act. There was a finding of that by the Ethics Commissioner. And we know that there's a big gap in the RCMP's work, and it's very curious about how that came to pass. If the RCMP were to pursue an investigation into the SNC LAVALIN scandal and Prime Minister Justin Trudeau, would you fully cooperate?
Of course.
Another law enforcement agency, the Ontario Provincial Police, for example, were to undertake an investigation into the SNC LAVALIN scandal, would you fully cooperate?
Of course.
Do you possess any documents related to the SNC LAVALIN scandal or the deferred prosecution agreement?
No, I left government in April 2019, 5 years ago.
Okay. And the question wasn't when you left government the second time that you've offered us that date. The question was about you having the documents.
I have no documents.
Why did Justin Trudeau go to such great lengths to pursue a deferred prosecution agreement for his friends at SNC LAVALIN?
I have nothing to add to my testimony at the Justice Committee 5 years ago.
You have nothing to add. So, there was no rationale. So, if I were to say that it was to help out a liberal-friendly firm, you have nothing to add to that?
I gave my testimony at 2 meetings of the Justice Committee 2 parliaments ago, and that's my account of events.
Well, the history is quite clear that there was not a case made, and we've of course heard the now famous recording of you and the then Attorney General Jodi Wilson-Raybould when you claimed, without any evidence and without any substantiation, it's yet to be provided, that it was about jobs. And we know that it was never about jobs. It was, in fact, about politics.
Thank you, Mr. Barrett. That concludes your 6-minute round. Ms. Damoff, 6 minutes, please go ahead.
Would you feel comfortable talking just in general terms about the importance of that separation, that police investigations are independent of the political arm of a government?
Well, certainly. I mean, that is my wheelhouse these days, is governance and public administration. And I've written a book on the tradecraft of politics. So the premise of your question, in a free democratic society, it's very important that the justice system operate independently. That includes the police, the prosecutorial service, and the courts.
Thank you very much.
Thank you, Ms. Damoff. And just before we go to Mr. Villemure, just want to clarify something. At the opening of your comments, you mentioned that you didn't know why, something to the effect that you didn't know why Mr. Wernick was here. And I just want to remind committee members that on October 30th, a motion was passed by unanimous consent to have the RCMP Commissioner, Mr. Pensance, the Ethics Commissioner, former Ethics Commissioner, and Mr. Wernick to appear before committee. and that is why he is here today.
And on the topic of cabinet confidence, you had mentioned that it's a long-standing convention. Is that correct in how you framed it?
About 8 centuries worth, yes.
And how does a convention compare to the laws and principles of parliamentary privilege as it relates to our ability to send for documents and evidence?
There's a role for the clerk which is defined in the Evidence Act, and there are often disputes between Parliament and the executive about the release of documents. You may recall issues around Afghan detainees years ago and so on. So there's always a case by case. It's not an absolute principle. You do not have the right to ask for my medical records or my tax returns.
But to be clear, sir, as it relates to a convention,
yeah.
As I'm to understand, and forgive me for having notes to better refresh my memory or cite the actual laws, but when we were constituted, we carried with us the Westminster system from the UK, and the supremacy of parliamentary privilege supersedes conventions. Conventions are agreements among parliamentarians, but parliamentarian privilege is actually supreme when it comes to the conventions of our abilities and our standing orders as it relates to standing committees to send for documents, evidence, and witnesses.
No, that's your interpretation, and I know it's the interpretation of the law clerks of the House. It's not an interpretation I agree with or the courts have always agreed with.
So who has primacy over the House of Commons, the courts and the clerk, or the members of Parliament?
It's not a question of primacy, one or the other. We have a legislative branch, an executive branch, and a judiciary, and there's tension among the three all the time.
And so within that, in the appearance before the committee, the RCMP commissioner noted about cabinet confidences, that the cabinet confidence is there for a reason. I think the interpretation of cabinet confidence, which as we discussed earlier, sometimes differs from one person to another. So you just mentioned you think that's my interpretation, you have a different one, and the Supreme Court says that cabinet confidentiality is protected as a matter of constitutional convention, which is what you just referenced, or the rules of behavior established by the government institutions that are not enforced by the courts, but are considered binding by those who operate the Constitution. So the people who operate the Constitution are the members of Parliament.
And the police and the prosecutors and the executive part of government. And this is a principle that's binding on all branches of government.
So do you think cabinet confidentiality should be further waived in the context of investigations conducted by the RCMP? Or should this notion of client-solicitor privilege, where the government is both the client and the solicitor, provide them a shield from any kind of insight and or I should say oversight for criminal accountability?
It's never that black or white. I think the onus should be to disclose as much as possible to formal legal processes like the police and the courts, but there may always be cases where redaction is appropriate. We're having a discussion now about divulgation of documents involving Chinese intelligence activities within Canada. It would be a very bad idea to simply turn over all the documentation without redaction.
Who decides what's redacted?
The clerk has a role in deciding what cabinet confidences are released on a case-by-case basis.
Who else has roles?
Legal advice to the clerk.
Does the cabinet have a role?
No, absolutely none.
Does the Prime Minister?
Nope.
In no cases or situations does the cabinet or the Prime Minister decide what is and what isn't redacted?
If you go back to a previous government, then the previous prime ministers have a role in whether to release documents of their ministry. And basically, you sequester the papers of each government when it leaves. So I went back to Prime Minister Harper a couple of times to get his consent to release documents related to the Norman affair because they had happened while he was in office.
So that acknowledges that
he gave that agreement, and we turned over the documents to the court.
And so would that also carry, by the same logic, that the Prime Minister Trudeau could waive cabinet confidence at any time, despite recommendations by the clerk and by legal advisors?
It's a discussion between the clerk and the Prime Minister. Ultimately, it is the clerk's job
to make the final decision.
Mm-hmm.
Is it ever the situation that staff well below the clerk make decisions on what redactions are?
There would be advice from lawyers and from people like the security intelligence people as to whether redactions were appropriate or not. I always took the view to disclose as much as possible, but you wouldn't want to disclose business confidences or intelligence services or personal names and so on. It's very similar to the process on access to information.
And in your experience, in your years, just to recap, forgive me for not being as familiar as your LinkedIn profile might indicate, but how many years were you in government?
38 years, 17 as a deputy minister.
And in that time, did you see a trend towards more cabinet confidences or less cabinet confidences? Is this a government that was transparent by default, or did they tend to have more instances where they declared a greater volume of work to be in cabinet confidence?
I'm not a historian, but I think the trend line was to be more disclosure. There was a running discussion between the Auditor General of Canada and the executive about the disclosure of documents related to the budget. I reached an agreement with the Auditor General, Michael Ferguson, at the time, and I increased the disclosure of analysis documents related to the budget to the Auditor General.
I believe that's my time.
Hello, Mr. Warnick. When did you learn that SNC LAVALIN was being a target of an investigation? I do not recall. When did your interview with the RCMP happen? It was during the summer after I left, in July perhaps? I'm not sure of the date. Who were the targets of the RCMP interview after you had spoken with investigators? I do not know. There was a series of questions posed regarding the chronology of lobbying by SNC LAVALIN. Did they ask questions on certain ministers? No. When I was interviewed by the RCMP, it wasn't the behavior of ministers that was being questioned, it was the behavior of SNC LAVALIN. Well, they can interview people who have to follow the Ethics Act. When you testified to the Justice Committee, the Ethics Commissioner had not completed his report and stated since then that the Prime Minister violated the Act. And the conclusion was that his actions were inappropriate because it went against the rule of law. And Mr. Trudeau infringed upon Section 9 of the Act. You stated at the Justice Committee that Ms. Jodi Wilson-Raybould defended, or rather had to make a decision. And do you maintain your position knowing that the Prime Minister broke the law? Apologies, I'm not sure I understood your question. The conclusion of the Commissioner was that he broke a section of the Act, Section 9. And during your testimony, you stated that the Minister had been subject to illicit activities, and the Commissioner had concluded the opposite. The RCMP may have prematurely closed its investigation on the Prime Minister. You were questioned by the Ethics Commissioner, and you stated that regarding the investigation, you were not questioned by the RCMP on the criminal aspects of the Prime Minister. You stated, as the previous minister, I asked what I could or could not say. I was told not to talk about the minister's opinion. And what are the things that you could not talk about at the time? I'm not sure. It was 5 years ago. Ms. Wilson-Raybould, before the committee and during an interview, stated that she didn't believe that there were any criminal activities. Mr. Warnick, you have a decision to make. You can shed a light on the potential criminal implication of the Prime Minister, or keep it to yourself. Saying that you don't remember is up to you. History will remember what you say. Why did you try to influence the Attorney General? I have nothing to add to what I've said to the Justice Committee and what I said to the Commissioner during the interview. Do you believe that my question was a threat? That was a question. Is that a question, Mr. Berthold? For Mr. Wernick? Please repeat the question. Did you find that my question was threatening when I talked about the impact on your career as a whole and how you will be judged? No. When a Prime Minister sends his clerk to have a discussion with a minister, that minister knows that the Prime Minister has the ultimate control on their career. Is it normal that Minister Wilson-Raybould felt threatened by how you alluded to the Prime Minister in talking with her? Because that was the feeling. Please, brief response. You have all of that in the Commissioner's report.
I wasn't around, obviously, when this happened. Certainly, the Honourable Murray Rankin and Charlie and others from my caucus likely would have dealt with this. So help me just get a sense for, when the telephone conversation happens between you and the former Attorney General, and you say the Prime Minister is in a kind of a mood, and there's an assertion that he wanted her to shelf the prosecution, and it says in quotes that he's in a pretty firm frame of mind about this. So I'm a bit worried. What would you be worried about? This is your language from the recorded conversation.
Yeah, you're asking me to dredge up memories from 5 years ago, and I gave my testimony on all of this to the Justice Committee and to the Commissioner. To the best of my recollection, this was an issue about the minister's role as a member of cabinet and the
Point of order, Chair.
Cabinet as a team.
Point of order.
Hang on a second, Mr. Wernick. Mr. Barrett, on your point of order, please.
Chair, you intervened in the previous round with very clear expectations about what's supposed to happen. Mr. Green's question was very straightforward to the witness, and the witness is now saying that he gave testimony about something that hadn't happened at the time. When he came before the Justice Committee, the recording that Mr. Green is referencing hadn't yet been released. Mr. Wernick didn't know he'd been caught. And so the expectation of the committee, of course, is, as you said, that the witness is going to answer the questions, not simply say, I've answered that question before. However, Chair, for your consideration, of course, committee can formally order that the witness answer the questions, and if he refuses, then it is a violation of this committee's privilege, which would need to be reported to the House. But I don't think it needs to come to that, but just think that perhaps one more urging and an opportunity for Mr. Green to restate his question so that we can get an actual answer from the witness.
Okay, thank you for that intervention, Mr. Barrett. That is a valid point of order. Mr. Wernick, I am now starting to get into one of those moods that you spoke of with the Prime Minister. I'm asking you to answer the questions directly. Mr. Green, I'm not going to start your clock. Restart. I'm going to ask you to restate your question, and the expectation of this committee, because they do have privilege, Mr. Wernick, to ask these questions, is for you to answer them. So, Mr. Green, go ahead. I'm going to give you as much time as you need.
Thank you very much. And this was referring to the December 19th, 2018 conversation that had been recorded when you told Ms. Wilson-Raybould that Mr. Trudeau was in a kind of a mood and, in her words, wanted to shelf the prosecution of the Montreal-based engineering firm. And I quote, these are your words as recorded and distributed, he's in a pretty firm frame of mind about this, so I'm a bit worried. And then you go on to say, I'm worried about a collision then, because he's pretty firm about this. I just saw him a few hours ago, and this is really important to him. So I raise that, sir, because in the context of previous testimony you just provided in this committee, you talked about feeling intimidated, or maybe not you feeling intimidated, but where that line could be crossed. But yet, as was mentioned earlier, when you are sent a messenger from the Prime Minister's office that talks about a mood, that talks about a collision course, like, what did you mean by that?
So, first of all, I'm trying my best to respond to the questions and reconstruct a sequence of events. I apologize to the members if I've got events of 5 years out of sequence and whether my testimony, which happened twice, was before or after other events. I don't have the chronology clear in my head. So if I mixed it up, I apologize to the committee. You're talking, I presume, about my first appearance at the Justice Committee? Or are you talking about I'm
talking about the recording that came out.
Yeah.
And I would say that it's a lot easier for you to operate in this committee if you just answer the questions. Then you don't have to think about what you did, and you don't have to think about timelines. Just answer.
Well, actually, the timelines matter to the answers. So yes, I do want to know the sequence of events.
December 19th, 2018.
Right, and that conversation was available to the commissioner. So I'm not sure what your question is again still. I'm trying to answer it. What is your question?
You said the Prime Minister was in kind of a mood and that the Attorney General was in a collision course. I'm going to put to you, sir, that sounds like a threat. That sounds like when you say that you arrived from meeting him a few hours ago and you came to her with that message, that sounds like a threat.
Certainly was not intended as a threat, and it's not the interpretation of the commissioner.
Those are my questions.
Thank you, Mr. Green. Mr. Cooper, for 5 minutes. Go ahead.
Thank you, Mr. Chair. Thank you, Mr. Wernick. 2 days before Jodi Wilson-Raybould testified before the Justice Committee, you drafted Order in Council 2019-0105 that partially waived cabinet confidentiality, correct?
No. I had left all of the issues about confidences and divulgation to the deputy clerk, so she would have supervised the drafting of it. It's possible I signed it off as the clerk.
No,
I don't remember.
You had no involvement whatsoever. You had no conversations with the Prime Minister, and the deputy clerk had no conversations with the Prime Minister?
As soon as I was invited to the Justice Committee, I stepped back and recused myself from all of the issues around document production.
You recused yourself entirely. Okay. So you wouldn't be able to comment, for example, on why the order in council was drafted in a way that prevented Jodi Wilson-Raybould from providing her full version of events?
I did not participate in the drafting of it. I'm sure we would have been trying to strike some sort of balance between the confidentiality of those cabinet meetings and Ms. Wilson and the specifics that Ms. Wilson-Raybould was going to be asked to testify about.
Jodi Wilson.
I did not participate.
Jodi Wilson.
I didn't participate in the drafting of that order.
So is it accurate to say that you recused yourself entirely from the drafting of that order in council and any discussions that may have taken place about expanding the scope of that?
Point of order, Chair. I understood that we were meeting today to talk about an RCMP investigation. That was
to the very heart of that issue.
Hang on, Mr.
So I've got the floor, Mr. Cooper. So rehashing something that happened 5 years ago that has been subject to numerous meetings of a whole bunch of different committees in Parliament. We're talking about the RCMP, and none of these questions have to do with an RCMP investigation, which my understanding, Mr. Chair, you brought that he was here to talk about what the motion was with regard to. Maybe we could just stick to that.
You were asking about my Twitter in the last round.
Michael, just hang on a second. Thank you for that, Ms. Damoff. I appreciate your words. Mr. Cooper, you have the floor, and you can continue on this, and I did stop your clock, and I expect that you're going to come back.
I expect Mr. Wernick to answer the question that I asked.
Go ahead, please.
Sorry, I lost the thread. What was the question?
Stop my clock.
Go ahead, Mr. Cooper.
I asked you, Mr. Wernick, before I was interrupted, that to clarify that you had, from the time that you had appeared at the Justice Committee, that you entirely removed yourself from discussions concerning the scope of the order in council and any further discussions or consideration of expanding the scope of that order in council.
That's correct. And everybody concerned was interviewed by the commissioner in the months that followed.
And to Ms. Damoff's point, it is of relevance to the issue of an RCMP investigation because we heard testimony from the RCMP that the central or strongest theory towards establishing obstruction of justice was whether the Prime Minister removed Jodi Wilson-Raybould to get an Attorney General who would make a decision the Prime Minister wanted, and that the RCMP was impeded by their investigation to determine that as a result of the parameters of that order in Council. Mr. Wernick, when you appeared at the Justice Committee back in 2019, you characterized your interactions and those of the Prime Minister and his officials with the Minister of Justice, Jodi Wilson-Raybould, as so-called lawful advocacy to appropriately raise public interest considerations to the Minister, particularly that SNC would move its headquarters from Montreal, resulting in the loss of at least 9,000 jobs. I'm going to ask you, what evidence did the government have that SNC LAVALIN would move its headquarters from Montreal if a deferred prosecution agreement was not entered into?
I think we went over this at the Justice Committee. There were representations by SNC, and there were public statements made by SNC, and there were market disclosures by SNC.
Sure. Mr. Wernick, you must have known that SNC had a financing agreement with the Caisse de Depot that required it to maintain its headquarters in Montreal for another 6 years until 2024. It was public knowledge that SNC had entered a 20-year lease at its Montreal headquarters. It was also public knowledge that SNC had announced major renovations to its headquarters in Montreal worth millions, and 2 days before your infamous December 19, 2018 telephone call with Jodi Wilson-Raybould, in which you specifically raised the issue of the 9,000 jobs and SNC moving its headquarters.
Hang on, Mr. Cooper. Go ahead with your point of order, Mr. Chahal, and I'll just advise you that it's been practice in this committee that I've given members their time to ask questions on a broad range of things in relation to this. If it's to object to the line of questioning to Mr. Cooper.
Mr. Chair, I haven't even made my point of order yet, so I'm not sure what you're objecting to.
Go ahead. I'm not objecting to anything. I want to hear what you have to say. Just hang on. Mr. Cooper, please.
My line of questioning.
Mr. Cooper is interrupting my point of order, which I have not had the opportunity to make.
Go ahead, Mr. Chahal. Go ahead.
So, Mr. Chair, I would like the opportunity to present my point of order. I'd asked Mr. Cooper the relevance of his questioning, and once again, you have not let me finish, Mr. Barrett. You're not the chair. Mr. Barrett, you're not the chair. If you let me finish,
Mr. Chahal, I know which direction you're going.
Well, you do not, because I haven't finished my sentence.
I do know which direction you're going on this.
All I would like to do is say the relevance to the point of order that Mr. Cooper on your questioning with the RCMP.
Line of questioning.
Hang on. Michael and Michael.
I presented my point of order.
I want Mr. Chahal. I want you to go through the chair on this. Okay, don't go through Mr. Cooper.
Thank you.
So you have a point of order that you're raising. State your point of order succinctly, please,
yes,
and then we'll go from there.
So if I'm allowed to do so, I will raise my point of order succinctly. I'd like to know what the relevance of the questioning provided by Mr. Cooper is, because this has nothing to do with the RCMP.
Mr. Chahal, I've been chairing this committee now for 18 months, and in every circumstance that we've had discussions at this committee, I give members a broad latitude to discuss and ask questions that they feel are relevant to the situation, with the expectation that they're going to bring it back. So you're not issuing a point of order. Your point of order is actually very subjective. So, Mr. Cooper, you have the floor. Go ahead, please. You have 53 seconds. Thank you for your point of order, Mr. Chair.
None other than 2 days before your infamous phone call with Jodi Wilson-Raybould, in which you raised the issue of jobs at SNC moving, the CEO had publicly stated that SNC LAVALIN was committed to staying in Montreal. So why did you tell Jodi Wilson-Raybould that jobs were on the line and there was a risk of SNC moving its headquarters when you had to have known that that simply wasn't true?
That was my understanding at the time, and that the law that Parliament created in terms of deferred
How is it
prosecution
possible?
agreements.
How is it possible that
Now,
could have
could
been your
you let-
understanding
could you let me
at the
finish,
time in the
Mr.
face of
Cooper?
everything that I
Mr.
laid
Cooper,
out?
let him-
Will you let me-
let him
Mr.
finish, please.
Will you let me finish?
Warnick,
You're badgering.
Your answer
You're
is simply
badgering.
Point of order.
Mr. Cooper.
Point of order.
Thank you, Mr. Cooper, for your line of questioning. That concludes your time. We're going to now go to Mr. Baines for 5 minutes. Go ahead with your point of order, Mr. Chahal.
Once again, I just want to acknowledge the witness is here to answer the questions, not to be interrupted by the member asking the questions. So if you ask a question, allow the member, allow the witness to provide an answer. And it was, I'd ask Mr. Cooper to
Thank you. I get the gist.
apologize for rudely interrupting the witness in the middle of his questioning.
I get
An
the gist of what you're saying, Mr. Chahal. We're now going to proceed to the second hour, which means we're going to reset the clock. And just a reminder to members that if there is an intervention, then a point that needs to be made, that it comes through the chair. I don't want to have banter back and forth between members. And I'm also going to remind members as well that relevance is subjective. And so I believe that members have their time to ask their questions. I also expect, as I said earlier, that members are going to come back to the point. So if you're interrupting because you don't like something you're hearing, that's too bad. Mr. Brock, you have 6 minutes. Go ahead.
Thank you, Chair. Mr. Wernick, the focus of my time with you will be on the concept of two-tier justice, two-tier level of justice. But before I get to that, today being March the 19th, when were you invited? When did it come? When were you known that? When did you know that you were going to be invited to this committee?
Oh, I don't know. It was about a week ago, I think.
About a week ago?
I can check my emails, something like that, yeah.
Okay, and then in the past week or so, what did you do to prepare for this meeting?
Just me and Google search.
Just sorry, what?
Just me and my Google search. I haven't spoken to anybody about this appearance.
No, that wasn't the question. How did you prepare? Did you review, for instance, your 2 transcripts of previous testimony at the Justice Committee?
I read the commissioner's report, I downloaded and read the 2 committee appearances, and I did a search for news articles.
Okay, that's a good start. Now, we know that the ultimate conclusion from the Dion report is that the Prime Minister directly and through senior officials used various means to exert influence over Jodi Wilson-Raybould. The authority of the Prime Minister and his officers were used to circumvent, undermine, and ultimately to discredit the decision of the Director of Public Prosecution, as well as the authority of Jodi Wilson-Raybould as the Crown's Chief Law Officer. I'm going to quote from her book, Indian in the Cabinet, that she says, "The efforts to pressure me either directly or through Jessica continued from September the 17th and onward. Ultimately, 11 officials from the Prime Minister's office, the Privy Council office, and the Office of the Minister of Finance made attempts. Over that 4-month period, there were approximately 10 phone calls, 10 meetings about SNC LAVALIN, culminating in a phone call I had with the clerk of the Privy Council on December 19th. Now, you didn't know that you were being audio taped, did you?
No.
No. And unlike yourself, because I did review with some great scrutiny your previous transcripts and your evidence from the Justice Committee, you didn't take contemporaneous notes, unlike Jodi Wilson-Raybould, did you, of all your interactions with her?
No.
So there was nothing that you could use to refresh your memory in advance of your appearance at Justice Committee 4 years ago, 5 years ago.
Between December and my appearance in February? No.
Yes. Okay. Now, in your opening statements, I don't know if it's your first or second testimony, you talked about two-tier level of justice, but only in relation to the fact that SNC LAVALIN eventually did not receive the DPA and ultimately, as we know, pled guilty to 1 count of fraud. So that's not the focus of the question. The focus is, in my view, there is a perception among Canadians and a perception among numerous members, myself included, that there was a political non-appetite by the RCMP to conduct a thorough investigation. Prior to the commissioner's attendance, not too long ago, they had roughly close to 4 years of investigating this particular matter. And unlike the ethics commissioner, who essentially interviewed 14 witnesses, you being included, the RCMP interviewed 4. Now, I know you've already opined that you're not going to talk about police operations, but given that discrepancy, do you think that there is a disconnect between in terms of how the ethics commissioner approached this investigation versus the RCMP?
I think the ethics commissioner's mandate given to it by Parliament is about violations of the Conflict of Interest Act. And the RCMP would be looking at a threshold of potential violations of criminal law, so they would be looking at it with a different lens. But it is entirely up to the RCMP whether they pursue preliminary investigations, fact-finding, final investigations, or move on to laying of charges. That's their job.
But the evidence is still the same. The evidence, and the RCMP confirmed it, that they relied upon the evidence received from the ethics commissioner. The ethics commissioner was ultimately stymied and was upset that he was unable to complete a fulsome report due to the actions of the Prime Minister, which is exactly the same rationale the RCMP had used in closing up their investigation because they could not obtain further information from the Prime Minister. Were you aware of that?
So I'm aware that that's what the commissioner wrote in his report. Yes, of course.
Now, there's 2 elements to any criminal charge. The RCMP were investigating obstruction of justice and intimidation of a justice participant. There's 2 elements. There has to be an act and there has to be a mental element, an intention to complete the act, known as actus reus, mens rea. I don't want to get into legal complexities, but that is the ultimate test. Did you review the testimony of the RCMP commissioner from a few weeks ago?
No.
All right. Now, I'm going back to some of the evidence that...
I'm sorry, Mr. Brock, you get like 10 seconds left.
No time.
Our last exchange, when you suggested that Commissioner Dion didn't come to the conclusion that there was a threat or an act of intimidation between yourself as an emissary of the Prime Minister to Ms. Jodi Wilson-Raybould, I refer to the Warnick report, page 3, paragraph 14, when it is stated that on the basis of the evidence gathered, he concluded in paragraph 285 of the Trudeau II report that individuals who acted under the direction or authority of the Prime Minister in this matter could not have influenced the Attorney General simply by virtue of their position. My reading of that says not necessarily that that didn't happen, but that by basis of your position, the Commissioner didn't believe that you were in a position to provide that influence on the Attorney General because you were not the Prime Minister. So that's a bit of a different reading. What's your response to that?
Well, Parliament created the commissioner to make these judgments of interpretation, and that's his interpretation.
And so it's based on the evidence gathered, and we're here today because there's a thought that perhaps not all the information was present. Would your understanding be that the commissioner would have had access to all the information necessary to make that decision?
I don't know. I mean, my conversation with the Attorney General was a matter of public record before he completed his report.
You had referred on multiple occasions that, almost as a warning, that a scenario where the government directing the police leads to an authoritarian culture. Is that an appropriate summary of your remarks?
I think that it is very important in a free and democratic society that the police make decisions about operations and investigations independently.
And when they don't, how would you I believe you characterize that as being authoritarian, correct?
I think it's what we see in partial democracies and authoritarian countries, and you can look at the headlines in a number of countries, Poland, Turkey, Russia, others, where directing or intimidating the police in terms of who they should investigate, who they should arrest, who charges should be played. That is not a full-blown democracy.
And what would your opinion be for the same scenarios where pressure is applied to the prosecution and not the police?
Same thing. I mean, that's why that is why the Harper government created an independent director of public prosecutions. That only dates from 20 years ago, and that was created specifically to ensure the independence of the prosecutorial service.
Why did you resign?
As I said in my letter, I felt I couldn't do the job anymore.
Okay. I think that's all that I have.
Do you own shares in SNC LAVALIN?
I don't own shares in anything.
Have you ever owned shares in SNC LAVALIN?
I've never shown shares in anything. I was covered by conflict of interest rules.
As someone who specializes in governance, what do you think about cabinet confidence being used to hide wrongdoing and shield members of the executive from effective investigation by police?
If that was the case, then that's not a very good idea. Not a good thing.
So we've had the RCMP before parliamentary committees tell us that they have not been able to productively pursue investigations because of the executive's refusal to waive cabinet confidence. So you would characterize that as what? You said not very good?
Depends what the confidences in question were and what they would have led to.
I think that we know that in these cases they would have led to charges being laid against Justin Trudeau, and that's why. That's your
hypothesis. We don't know. I don't know what was redacted, what was withheld, and what was produced.
Indeed, we don't know, because the executive has used their power. The Prime Minister has used his power to shield himself from effective investigation by police. It creates a real problem when we don't know what we don't know. We don't know. We don't have anyone who watches the watchers, including our federal police. And on that, in a previous response, you said that when politicians start meddling in the justice system, it's not full democracy, it's authoritarianism. But that's what we saw with SNC LAVALIN, isn't that right?
Well, where was the interference with the justice system?
Well, sir, welcome back from 2019. I know that you had a front row seat at the time. We had the Prime Minister who was found to have used his influence to pressure the Attorney General. That's a finding of an independent officer of Parliament. That's not my opinion. We know this to be a fact, and we know that you, sir, on doing the Prime Minister's bidding, doing Justin Trudeau's bidding, in an extended phone call, put tremendous pressure on then Attorney General Jodi Wilson-Raybould to do exactly what the Prime Minister wanted, and that was to give a deferred prosecution agreement, or for the uninitiated, effectively a get-out-of-jail free card for a liberal-friendly firm, friends of the Prime Minister. And that's pressure. And what happened when Ms. Wilson-Raybould didn't do what she was supposed to do in the Prime Minister's estimation? She was kicked out of cabinet. And when someone spoke up on her behalf, they were kicked out of cabinet in Dr. Philpott. And for their dissent, they were both ejected from caucus. So it seems like that's a pretty heavy hammer the Prime Minister was able to carry. And what did he do? He put in a Justice Minister who would do what he wanted to have done, to do his bidding. That is, as you described it, authoritarian, because that's exactly the kind of interference in the justice system that happens in tin pot dictatorships.
So that's one narrative. Another narrative would be that the maximum pressure put on the Attorney General was to provide reasoning and rationale why she declined to use a tool, an entirely legal tool that was provided by Cabinet, the Deferred Prosecution Agreement, which was made available for certain cases. Deferred prosecution agreements are not an illegal act. They are a legal tool. It's how we got the two Michaels back from China.
Yeah, no one has said that a DPA is illegal. What we're saying is that the Prime Minister inappropriately interfered in the administration of justice in this country. And someone who would be willing to do that can't be trusted to, of course, protect themselves from prosecution by the RCMP for obstruction of justice using powers of the executive. That's blatant interference. Do you have any regrets about how Jodi Wilson-Raybould was treated?
Not every issue of ethics or behavior rises to the level of a breach of criminal law. That is why Parliament created a conflict of interest and ethics commission.
Regrets, sir. Do you have regrets about how Ms. Wilson-Raybould was treated?
I have no regrets about anything that happened. We all made our best decisions at the time with the information we had, everybody involved in the affair.
Thank you, Mr. Barrett. Ms. Damoff, for 5 minutes. Go ahead, please.
Thanks, Chair. Mr. Warnick, can you maybe, gosh, I don't even know where to start after that line of questioning. You know, we're here to talk about why the RCMP didn't lay charges.
Mr. Warnick, on a couple of occasions, you mentioned that it's 5 years ago, a long time. I think you'd stated that you're not a historian, but you are a professor and you are teaching governance. What lessons do you teach your students about this whole affair?
I don't talk about this affair as a specific. You can read my book on governance.
I'm just going to tell you, from where I sit, that sounds supremely arrogant when I'm asking you a question in this committee. I'm not interested in buying your book, sir. I'm interested in you answering the question, what lessons were learned from this whole affair? And if your suggestion is that you don't delve into this conversation at all into your class, that's fine. But to continue to say, like, check my CV, check my LinkedIn, read my book, buy my book, it's not landing the way you think it probably is. So I'll ask you again, what lessons learned do you have from this affair, whether to students or to this committee for recommendations? Because ultimately, we have a responsibility to have some kind of report or recommendations coming back from this. And 5 years later, it's still a mess. It's still murky, and it still undermines the people's faith in the democratic institution here. So Parliament can change the laws. So 2 specific recommendations. One is that the law that was drafted and implemented by this Parliament in 2018 about deferred prosecution agreements has some ambiguity in it in terms of the evaluation of economic interest, which was the subject of one of the conversations. So you should go in and reopen the law and take a look at the language on what can and cannot be used in considerations around a deferred prosecution agreement, because it will come up again sometime in the future. So there's a job that only you parliamentarians can do. And if you're not happy with the rules about disclosure of cabinet confidences to police forces or judges, change the law. Thank you. It really wasn't that hard. I appreciate that answer. That's all my questions.
Thank you, Mr. Green. Mr. Cooper for 5.
Thank you, Mr. Chair. Mr. Wernick, your telephone conversation with Jodi Wilson-Raybould on December 19th, 2018 was made at the request of Justin Trudeau, correct?
I'm sorry? I didn't hear that.
Restate the question,
Your
please.
telephone conversation with Jodi Wilson-Raybould on December 19th, 2018 was made at the request of Justin Trudeau, correct?
Not specifically to call her, but my recollection of it is, and you can read me back my testimony, is that he wanted to find out what her rationale was for not pursuing the DPA at the time.
And so Justin Trudeau testified, but he did make that request in his testified to the Ethics Commissioner. And to put some context with respect to that call, hours before you initiated that call, you had met with the Prime Minister, his Chief of Staff, Katie Telford, and his then Principal Secretary, Gerald Butts, in which SNC LAVALIN and the issue of deferred prosecution agreement came up.
Yes, that was our last meeting before the Christmas holidays and a 2.5 week break before we all came back in January.
Thank you for that, Mr. Wernick. I appreciate your answer. No, I appreciate you answered the question.
Point of order. Hang on. Mr. Cooper, please, I see your point of order. I'm going to maybe solve what you're going to be asking. I would just ask that you give Mr. Wernick an opportunity to answer the question, please, Mr. Cooper. With it, okay.
10 more seconds.
Thank you, Chair. I just thank you for that.
Go ahead. Go ahead, Mr.
So as I said to the
answer
committee,
the
it was one of many issues that we discussed at a Christmas holiday wrap-up meeting.
Okay. Thank you for that. And to put further context with respect to that call, one day before that call, Jodi Wilson-Raybould's chief of staff was summoned by Katie Telford and Gerald Butts and was told that by Butts and Telford that they didn't want to hear anything more about legalities. They wanted to get a deferred prosecution agreement done. So when the Prime Minister asked you to make this call, he was effectively giving Jodi Wilson-Raybould her last chance to make the decision that he wanted before he fired her, wasn't he?
I'm not aware of the conversation that Ms. Telford and Mr. Butts had at the time. When I had my call, I wouldn't have been aware of that. And this was before Mr. Bryson resigned from cabinet and created the need for a cabinet shuffle.
Well, Mr. Wernick, that conversation of Ms. Telford and Mr. Butts is now well documented, backed up by contemporaneous notes taken by Ms. Wilson-Raybould's chief of staff. So let's look at the facts. After months of pressure on the Attorney General and the day following the meeting where the Prime Minister's chief of staff and principal secretary tell Ms. Wilson-Raybould's chief of staff, we don't care about legalities, just get it done, you give Ms. Wilson-Raybould a call at the request of the Prime Minister, wherein you state the Prime Minister is quite determined that he's going to find a way to get it done one way or another, that he is in a very firm mood about this, and you were worried about a collision occurring between him and her. So those are some very strong words, veiled threats. Why would you use those words if, in fact, it wasn't Jodi Wilson-Raybould's last chance to make the decision that the Prime Minister wanted before he was going to fire her?
You're hypothesizing an intention to fire her, which I was certainly not aware of at the time.
Well, you issued a number of threats after the Prime Minister's chief of staff had only a day prior and his principal secretary said, we're done with the legalities. And then guess what? 2.5 weeks later, after this phone call, following the Christmas break, she was fired as Attorney General. So taken together, I would submit there is no reasonable conclusion that can be drawn other than that the Prime Minister fired Jodi Wilson-Raybould when she wouldn't acquiesce to his demands to interfere in the criminal prosecution of SNC LAVALIN. And you know what that's called, Mr. Wernick? It's called obstruction of justice, isn't it?
I think that's for the police to determine.
Mr. Wernick, you couldn't back up with any credibility the issue of SNC moving its headquarters. What about the jobs? What analysis had the government taken that at least 9,000 jobs were on the line?
So I think that was all covered at the Justice Committee and the production of documents for that. I don't have any of that material in front of me.
And the answer that you gave to Ms. May when she posed that question to you is that no analysis had been done.
There had been statements by the company and market disclosures, and there had been representations by the company, which are on the record.
This was a pressure campaign made by the Prime Minister, not in the public interest. It was clearly the Prime Minister acting in the interest of SNC LAVALIN, and that's exactly what the Ethics Commissioner found.
Thank you, Mr. Cooper. Okay, thank you, Mr. Housefather and Mr. Wernick. Mr. Brock for 5. Go ahead.
Thank you, Chair. I'd like at this time to move a motion that pursuant to Standing Order 108 Sub 1 Sub A, the committee order Mr. Wernick and the Privy Council Office to produce all records of communications between Mr. Wernick and any board members, employees, or representatives of SNC LAVALIN, now Atkins Realis, between the period of November the 4th, 2015 to March 19, 2024, and that these communications be provided within 14 days of the adoption of this motion. And I hope that we have unanimous consent.
So the challenge that we have right now is that we do have a motion that's been presented. We have to deal with the motion as presented on the floor. And Mr. Brock, and I appreciate the intervention of Mr. Villemure, and I appreciate your intervention. Mr. Brock has proposed a motion. He did ask initially for unanimous consent on his motion, so I'm going to seek that. I'm going to seek unanimous consent. Do we have unanimous consent on that? Yes. Okay, Mr. Villemure, we, Mr. Green, and I just need unanimous.
I don't think we agree because we wanted, as Ms. Damoff mentioned, to potentially offer some amendments.
Okay, so there's no agreement for unanimous consent.
Okay, yes, sorry,
Mr. Housefather, I'm going to accept that. So on the motion, not seeing any further discussion, I am going to call for a vote. So, Madam Clerk, if you want to take the vote, please.
Point of order, Mr. Chair. I'm so sorry.
Chair, my hand was up.
It wasn't, Ms. Damoff, because I did look at the screen. I'm sorry, but it was not. So I called the vote. I'm going to go to the vote right now. Thank you. Sorry. Go ahead, Madam Clerk.
Point of order. There is no vote called. Point of order. There's no vote called, Mr. Chair. Ms. Damoff had her hand up. Ms. Damoff had her hand up. Mr. Chair, you were not paying attention. You're looking at your colleagues, looking for direction.
Concerned with the way that you are handling this particular motion, even in supporting the motion. So I would ask for your indulgence to allow debate when motions are called, because the precedent you set by not allowing debate when it's called and kind of surreptitiously calling votes, it shows a level of partisanship that I haven't seen in you to date, sir. So I would appeal to your reconsideration of that and allow a debate to happen and allow that process, as is the standing kind of procedures and courtesies within the way in which we conduct this committee.
On some good faith, I know you had an amendment, Ms. Damoff. I'm going to give you an opportunity to present that amendment. And then my hope is that we can go to a vote at that point and dispose of this motion, because I'm sensing that most of the committee is in agreement with what Mr. Brock has proposed. So I'm going to go back and I'm going to allow you, Ms. Damoff, to put your amendment forward, and then we can deal with it. So go ahead, please.
So thank you, Chair. And just in the spirit of what Mr. Villemure had suggested, I would just suggest removing the words "and the Privy Council office." That would allow Mr. Wernick to provide the documents that he has, as well as the non-existent documents between 2019 and 2024. And once we've received those and reviewed them, if we feel that we need more information, we can deal with another motion at that time.
Okay, thank you. So Ms. Damoff has proposed an amendment to remove "and the Privy Council office." So any discussion on that amendment? Do we have consent to? We don't have consent. Okay. So why don't we go to I don't see any further discussion, and I don't see any further discussion. So I'm going to go to the vote on the amendment. Go ahead, Madam Clerk.
The vote is on the amendment from Ms. Damoff to delete the words "and PCO." Mr. Baines.
Yes.
Ms. Damoff.
Yes.
Mr. Housefather.
Yes.
Mr. Sorbara.
Yes.
Mr. Shahal.
Yes.
Mr. Barrett.
Why would they want to get rid of the PCO documents? Yeah, vote no.
Mr. Brock.
No.
Mr. Cooper.
No to the Liberal cover-up.
Monsieur Villemure. Mr. Green. That's a no?
No.
Yeas 6, nays 4, oui 6, non 4.
Okay, so the amendment carries. We're going to go to the main motion as amended. Mr. Barrett, go ahead.
This is fascinating that we have Liberal members who are working overtime to try and bury documents from PCO. So So we have Mr. Wernick, who says he can just email them over this afternoon, what he's got. So that satisfies that. The documents that he says don't exist, obviously he doesn't send those. But the documents from PCO, I heard Mr. Baines say they don't exist. Well, then that's a very quick return for PCO to make. So if there's nothing to see here, I really don't understand why that they are so determined to keep the information from coming out. You'll recall that we were told that sunshine is the best disinfectant, and that's what we would see from Justin Trudeau. But what we're seeing from his parliamentary secretaries.
Chair, are we debating the motion in front of us or my amendment? Because my amendment's already passed.
We're debating the main motion as amended.
Okay,
Go
so
ahead.
the main motion doesn't even mention PCO anymore. So I don't understand. Mr. Barrett is accusing me of trying to cover something up. We voted on the PCO part. That's done.
Mr. Barrett is on the main motion. He's discussing the main motion. He has the floor, Ms. Damoff. Go ahead, Mr. Barrett.
We have Ms. Damoff, a parliamentary secretary for Justin Trudeau, who literally doesn't even want me to say PCO. She's trying to say that it's out of order for me to talk about PCO documents that were in the motion. And we have the former clerk of the Privy Council in front of us dealing with Justin Trudeau's SNC LAVALIN scandal, where he used his powers to protect himself from effective RCMP investigation. And now we have multiple parliamentary secretaries and members and Liberal chairs who are trying to, again, cover up what happened. And it's absolutely egregious, but of course it's also transparent to see that that's what we're doing. So voting for a motion that is completely neutered, it's not providing the transparency that Canadians deserve, is an affront to to the basic premise of openness, even by how far it's fallen under this government. We seem to plumb new depths with their interest in trying to cover up for a corrupt Prime Minister every day.
Okay, thank you, Mr. Barrett. Ms. Damoff, your hand is still up? Or is it?
Yes, Chair, it is. Thank you. Mr. Barrett insists on using words like cover up and corrupt. And he knows that I'm going to get my inbox full. Already social media is talking about me being a pearl clutcher because I don't like getting the kinds of messages that I get. I think maybe I should just walk over to Mr. Barrett's office and show him the kind of wording and emails that I get and the things that I'm called. We are not a corrupt government, Mr. Barrett, in spite of what you want to say. The fact is that Mr. Villemur put forward a reasonable suggestion, especially since we're dealing with this at the last minute in committee. The change was, I was quite clear that if the documents that we receive are not adequate, we can ask for more documents later.
Mr. Cooper?
Thank you, Mr. Chair.
On the motion. On the motion.
I know that it's really, really difficult, it must be, to have to come in every day and defend Justin Trudeau's corruption, but that's what these Liberal MPs have to do. And it's really, I hope the voters in my riding take note. Look, this motion has been completely neutered, it's been gutted, and there's only one explanation for it, and that's to continue a cover-up that has gone on for 5 years.
That's right.
Vote against the motion.
Thank you, Mr. Cooper. Ms. Damoff, your hand is up. I suspect that it was for your previous intervention, or is it for a new one?
No, Mr. Chair. I mean, again, maybe I'll have to walk over to Mr. Cooper's office. I don't think that anyone in this committee room right now wants to try and destabilize what our country is like. But these consistent claims of cover-up and corruption. Mr. Chair, I think I was pretty clear when I moved my amendment that this was to provide documents quickly and then we can revisit. That is not a cover-up, and I wish my colleagues would retract their comments. And I think we're probably ready to go to a vote, Chair.
So just need everybody's attention, please, just so that we're clear on this, that the expectation is that it will be the decision of the committee on these documents that are received by Mr. Wernick, okay, if in fact we need the PCO. So if we need to include that in the motion so that it's clear, but my understanding and the clerk's understanding, based on the discussion that's happened today, is that that's the way it is. It will be a decision of the committee as to whether to get the PCO documents within the 14 days. Now, that 14 days is after the receipt of the documents that Mr. Wernick is going to provide to the committee. Okay, so Mr. Barrett, on this, does that, first of all, does that clarify things, Ms. Damoff? Thank you. Go ahead, Mr. Barrett.
So the challenge, of course, is that that supposes that there's an interest in moving forward with the rest of the documents. What I would prefer to see is if we're not putting the PCO documents being ordered today, that it's time triggered. So I appreciate there needs to be some subjective analysis of that, but if it comes back to the full committee, we've been like mired in this for quite some time already. Mm-hmm. I would forecast that the same would happen again, and so I would rather put it to the chair. That the documents have been well received or not, and then if not, then the production is issued. But if it comes back to the committee, that might just be the end of it then.
So, might I suggest that if, and I'm just throwing this out there, if one party is not satisfied, then that could trigger the discussion at the committee, which I can facilitate at a committee meeting under committee business. I'm just trying to figure out some sort of mechanism that we can use, and to me, that would be the mechanism. If somebody indicates to me that they're not satisfied with the documents that Mr. Wernick provides, then that would force a discussion at committee, at which point we would make a decision on the PCO. After a committee discussion. Go ahead, Ms. Damoff.
I think that's reasonable, Chair. If someone on the committee is not satisfied with the documents, then you can call a committee meeting. I think that's very reasonable.
So I'm going to accept that. And now we are on the main motion as amended. I don't see any further, tell me that's not a discussion. No, it's a thumbs up, okay. All right, I don't see any discussion. Do we have consensus on the main motion as amended and not require a recorded vote? Okay, we do. Mr. Green, thank you. Okay, so the motion is adopted. Mr. Wernick, I want to thank you for your time today and thank you for your patience in sticking around and providing us with the information that you did.